about the difference in the role that you're playing here, speaking before a legislature and as a sitting justice when it comes to making decisions on death penalty?
Well, I think probably the easiest way to describe that is yesterday I had an email telling me it's my job to pick a date for someone on death row because Chief Justice O'Connor was the prosecutor in the case, so she's recused. So I have a duty under the law to follow that law. At the same time, we are admonished in the rules that apply to judges that we have a duty to step forward and advocate for changes that we think would lead to an improvement in the law. I think abolishing the death penalty would be a needed improvement. It will happen. Will it be today, tomorrow, in this session of the General Assembly? More problematic. But the day will come when Ohio no longer has a death penalty.
Why do you say that?
You can look at the national trends. The U.S. Supreme Court not long ago said can't execute the mentally retarded. I don't know why we ever thought we could, but we did. Then they said you can't execute anyone who's under the age of 18 when they committed the crime. I think the next step will probably be taking a look at those who have serious mental illness when they committed the crime. Different from the McNaughton rule, which essentially says if you knew right from wrong, it doesn't matter how sick you were, you can be convicted and sentenced to death.
Would you say, though, a conflict of interest of any sort if you were to encounter another death penalty case in the future?
Why, I encounter them, we probably have a couple in play right now. No. Prosecutor Watkins would like me off. And a point that I didn't make in there is there's an inherent unfairness in the way death cases are tried, in that prosecutors, through peremptory challenges, kick everyone off who say that they have some difference or disagreement with the death penalty. It doesn't matter if they say, I can follow the laws, the judge gives it to me. If they have a personal discomfort with the death penalty, they're off the jury. So you start with a jury that all favors the death penalty. That's probably not right. We've not seen that test case. But yeah, you will find my name on opinions, continue to find my name on opinions that uphold the death penalty. And you will find my name on a couple of orders to carry out an execution. That's entirely different than advocating at the General Assembly it's time to change the law.
Even though you've expressed your opinion today, though, you don't feel that in the future with other cases?
No, not at all.
Why is that?
Well, it's as simple as I'm constitutionally obligated to follow the law. The law is that we have the death penalty, and there are a lot of rules on how it's carried out. I've dissented on some, and I've voted to uphold most of the cases that we've seen. I would expect to continue to follow that pattern.
Justice Pfeifer, you said earlier on in your testimony that a life on parole would be worse than it was.
No, that was Representative Tranter said that when we were passing the bill. I don't agree with that. Didn't agree with it then. That makes no sense to me.
Well, I mean, I did hear you say earlier that in fact that you thought that the reason you thought that the chair was better in some sense because it was gruesome and it was.
Oh yes, yes.
And then you said that
if there is any argument for a deterrent, the more unpleasant, the more unspeakable the method of execution, okay, so the more likely would be to be a deterrent. But if you look at the data from states that don't have it, you see roughly the same number of murders, aggravated murders. So it's impossible to make a case that the death penalty deters anyone. And if you, as I've had occasion to do, is see these crimes after they're committed. These are not smart people. They really didn't think through what they were doing. A lot of times it's in the heat of the moment. Boom, away you go. And because we have felony murder, for example, one that Governor Strickland commuted and I descended on. Guy and his girlfriend go get loaded at a bar. These are not young people. They go home, they get in an argument. He ends up killing her. He decides to go back to the bar and drink some more. He takes her car keys and drives her car back to the bar. That got him the death penalty because he, quote, stole her car. That ordinarily would have been something other than a death case, but because the prosecutor could add that in. Kidnapping's another one. They always charge now kidnapping to get it to the death penalty. And it's rarely what we would think of as kidnapping.
So you do believe a quick and painless death is worse than life on parole, that a prisoner would view it that way?
Oh, yeah. Yeah.
Do you think that the task force that the Supreme Court currently has should have a broader mission than looking at the fairness of law?
Well, the way it's constructed, I expect it's a train wreck in the early making because she put Joe Dieters and Dennis Watkins, the two biggest advocates of the death penalty, on it, along with some people who are opposed to it. So I would expect there will be a majority report and a minority report, and the focus probably will be on the enormous prosecutorial discretion. So that here in Franklin County, as you know, not many death cases. Not that many in Cuyahoga County, the state's biggest county. Hamilton County, different story. So I think a lot of the focus on their report will be the enormous and unchecked prosecutorial discretion, hence the geographical differences from county to county.
But do you expect any legislative or court rules to be enacted as a result of what the task force comes up with? In other words, do you expect changes to capital punishment law based on what
I think there probably will be incremental. I would be pleasantly surprised if this committee moved this bill. I think they should, but I would be surprised if they did. But yes, I think you will see changes. I think folks will begin to look at the profound mental illness that many folks have who've committed these crimes. Again, I think of one that I descended on. It wasn't the McNaughton test. He didn't pass that, but a guy up in the northeastern part of the state murdered and chopped up his girlfriend and her son, put them in the freezer, took a bus to Columbus and then a bus to Wheeling. Then he took a bus back, and he ended up in Lorain and found a parish priest and confessed. Now, that guy was about as nuts as you can get. But he still knew right from wrong, therefore he was not exempt from the death penalty. So I think that's probably the next area where the U.S. Supreme Court will probably be moving incrementally, and they have over time. And again, I think one of the things that I didn't mention is we don't find ourselves in great company when we look at the countries that still use the death penalty. I think we're 7th in the world. If we follow China, Saudi Arabia, Iran, that's the kind of company we're keeping with the heavy use of the death penalty. And I think that's uncomfortable to most citizens as they begin to recognize that most of what we consider the developed countries don't use the death penalty at all.
Justice, given the way that this law has played out, over the years, as you thought about your role in helping to write this law, do you have any regrets in having done it?
Well, my big surprise was that the Supreme Court has broadened its reach. Prior calculation and design is about a millisecond anymore. And when we put it in, we were thinking people who planned a murder. That's just no longer the case, and that's a result of a number of Supreme Court decisions, many of which were made before I even arrived at the court. I have an ongoing discussion with my colleagues where it's basically a domestic case that boiled out of control and murder incurred because we clearly meant to get the garden variety domestic dispute where murder ends up being the outcome out of the death penalty. And some of my colleagues go, well, you couldn't have meant that. I think they view it as a harsh view toward women. But that is, in fact, what we were trying to do then. And then kidnapping. We have a number of cases in which we have essentially said if you point a gun at somebody for 2 or 3 minutes, you've kidnapped them. Well, that isn't what any of us thought kidnapping was then or now. But our court, again, has broadened that definition to the point that the reach of this statute is anything but narrowly tailored. So that has surprised me. That in part has been at the hands of the court on which I served over time.
Justice Pfeifer, assuming you could pass a law that said, you can't kill someone in Ohio who is severely mentally ill, attested by different parties so that the deck isn't stacked, would you then say, I'm just trying to break this down, would you say the geographic issue, the variance, is the strongest argument against this?
It probably is. And again, I have not tried. Andrew Welsh-Huggins did the best job of laying that out. That's a very strong argument. It is geographical. It's undeniably so.